if the right of choice of counsel is a fundamental right in Canada and in America, why are you, Representative Omar Khadr, and being part of the process which then denies him the right to his choice of counsel?
Well, unfortunately, the Military Commissions Act does discriminate against non-U.S. citizens in terms of the right to counsel. It does contain a limitation that is similar to the limitation that exists in courts martial generally, which restricts participation as counsel or civilian counsel to an individual who is a member of a bar of a court of the United States, and that's probably a defensible limitation, but the prohibition against non-U.S. citizens is indefensible. Having gone through this process once before with the Al-Sharbi case, under a previous version of the system, it did not afford a right of self-representation. It became apparent to me that at least at the outset, the government's theory was, to design a trial process that would essentially exclude the defendant as much as possible. He could be actually thrown out of the courtroom if there was classified evidence, and he wouldn't get evidence, and there were certainly draconian restrictions on access. And so the theory, I think, for the Department of Defense was to have a military lawyer there who would essentially make the process look legitimate. A military lawyer would be more amenable to orders and direction, I think, from the fly. And so we could essentially have this Star Chamber-like proceeding with the military lawyer acting as a fig leaf. That was certainly the old commission system, and so now there is a right to self-representation, but there is still a requirement that a military counsel be detailed to the case, and that is difficult to defend as a matter of due process. With that said, no detainee is required to be represented by the military lawyer, and so the detainee could either elect to proceed with self-representation, or could associate qualified civilian counsel and marginalize, if not completely exclude the participation of the military lawyer. But this idea of having a military lawyer assigned to the case is unfortunately a vestige of the old process.
But hasn't Omar already exercised that right and asked for Dennis Edney to be his representative? Why are you still there?
I don't know that I can comment on. Well, I think I just explained the rules of why I remain detailed in the case, regardless of what his expression is. I'm not sure that I want to get into it.
Commander Kuebler and I work together. As he's honestly put it, it's a very difficult situation he's been in. We do work together. We have tensions, as any legal team does, but we are working together. In fact, Commander Kuebler is primarily responsible for me getting into Guantanamo. It took years for me to get into Guantanamo. Commander Kuebler has been responsible for assisting and streamlining and various benefits for Omar Khadr. There is a tension. Of course there's a tension. Commander Kuebler is he's from the same authority as I indicated that I've been attacking for 5 years. So he's put in a very difficult position. And our job, and we've talked about that, our job is to try and finesse that role in a manner that at least gives a sense to Omar Khadr that his interests are being taken care of. Thanks.
If someone can give us an understanding of what this particular suit is all about, and why is it different from the other three? Perhaps, Jennifer, if you want to start, and then we can move to Bill and Dennis.
The question before the court is whether or not detainees who are held by the United States in the complete custody and control of the United States can go to courts and exercise their habeas rights to challenge the basis of their detention. Most of the detainees, there's 340 detainees left in Guantanamo. Only 10 have ever been charged at all at any point in time by a military commission, ever. The United States government only plans to charge between 50 and 80, depending on who's talking on a given day. That leaves over 300 detainees in Guantanamo, who the United States has held for close to 6 years now, and plans and wants to continue to hold, who have never had access to a court of law to review the factual and legal basis of their detention. The Supreme Court, when Congress last year passed the Military Commissions Act in 2006, it took away the right of detainees to go to court to bring a habeas claim. That case has worked its way through the lower courts. It went up to the Supreme Court. In February, the Supreme Court said, we're not going to hear this case. And over the summer, it reversed itself and said, actually, we are going to hear this case. That's highly, highly, highly unusual. And the hope is, and our strong hoping, is that what that means is that, in order for the Supreme Court to review a case, they need 4 votes. They need 5 votes to win. We are pretty sure that there's 4 votes on the Supreme Court that are in favor of habeas restoration, but that Stevens, one of the Supreme Court judges, voted against hearing the case because he didn't want to bring up the case and then lose. And that presumably the assumption is, and we don't know, it's a complete black box in terms of the internal deliberation, is that Kennedy, one of the justices who's really the swing vote, indicated, or there's hope, or Stevens thinks that he's changed his mind, and so therefore they voted to reverse course and to bring the case up. That's the hope.
Yeah, I mean, just to comment on Omar's participation in the case. Obviously, the case involves a number of petitioners detained what's going on today. Omar is the only one currently charged with offenses to be tried by military commissions. So, forgive me if this gets a little technical, but one of the issues that's going to be reviewed as part of this determination of whether or not the Military Commissions Act is constitutional and separate to strip detainee habeas jurisdiction is whether something called the Detainee Treatment Act, which is the federal statute that was passed by Congress after Rasul to create essentially an alternative to habeas as part of the first effort to strip the courts of habeas, is a constitutionally permissible substitute for habeas corpus. And so that's the issue that the court is going to have to grapple with. I don't know that we know how they're going to come out on that. The District of Columbia Circuit Court of Appeals issued a decision this summer in a case called Bismola that somewhat expansively construed the review provisions of the Detainee Treatment Act in such a way as to probably strengthen the government's claim that it's an adequate substitute. The point that we have tried to make in Omar's case, we've actually filed a separate brief with the Supreme Court concerning these issues, is that there are really 2 distinct types of habeas corpus claims at issue in the detainee habeas litigation. What I call detention claims, the claims brought by detainees who have not been charged to say, there's no factual or legal basis for my detention, and jurisdictional claims to the exercise of jurisdiction by military tribunal. And so we filed a brief that says, in essence, that the detention-related claims are clearly in front of the court, and so we would ask the court to limit its decision to those claims and not reach the separate question of whether or not the Detainee Treatment Act is an adequate substitute for habeas with respect to this other class of claims, or if you do reach the merits of the issue, then to apply that separate analysis and determine that it doesn't provide an adequate substitute. So there is a brief that's been filed that's separately from the other petitioners on behalf of Omar, putting those positions before the Supreme Court. Yes.
Very briefly, at the end of the day, I think that politics will play a role. We've had Rasul, Hamden, and on each occasion we've had Congress come to the rescue of the Bush administration when faced with decisions from the Supreme Court that were criticized and attacked and overruled the Bush administration's determinations. For example, we had the Military Commissions Act, which came out and created the mess we have today. I think the big question is, at the end of the day, regardless of what the Supreme Court does, is the will of Congress still as strong in favor of propping up the Bush administration or not? And I think obviously there seems to be a great sense down south that Congress is now starting to throw its weight around.
There's a variety of senators and representatives in Congress who are introducing and trying to move legislation to restore habeas for the time of the day detainees. And there was a vote in the Senate today where 56 out of the 100 senators voted to restore habeas, which really, in a lot of ways, is a victory. A lot of senators reversed their vote from last year. It wasn't enough to pass. Those Senate rules required 60 votes if there's a filibuster, so it didn't actually pass. But it does send a signal that's important in the way that politics and the court have an interplay, and also in terms of moving this issue forward. So, well, not an absolute victory. There was a partial victory on this precise issue today.